The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. There are 4 cases to be submitted to the court today. One case is without oral argument. That is the case of In Re W.T. That case is hereby submitted without argument. The first case with oral argument is In Re Guardianship of L.Y. I believe the first person to go will be attorney for mom, Ms. Eisentrager? Eisentrager. Sorry, I butchered that. Go ahead.
May it please the court, counsel. My name is Dani Eisentrager. I represent the mother, S.W., in connection with her request to terminate the guardianship of her daughter, L.Y. When L.Y.'s parents parted, they decided that it would be best for her to stay with her grandparents until they could get settled. Thereafter, S.W. was presented with guardianship papers. She consented on the promise that it was going to be temporary. The mother obtained employment and a stable home. She visited regularly with her daughter. By all accounts, they have a loving and bonded relationship. SW is a good mother. She has no substance abuse issues. She has no criminal history. She has no abuse or neglect allegations. SW's fault is that she became a mother at the young age of 16. She then married young. That didn't work out. When that didn't work out, she needed time to stabilize her life and get in order so that she could have her daughter in her care. Thereafter, she requested that the guardians return her daughter to her. Those requests went unanswered by the guardians. The mother also sought legal advice from 2 attorneys prior to yet retaining myself and bringing this action.
Go ahead and kind of jump to the chase here. Some of the arguments that you've made in your brief, of course, are constitutional in nature. Are you raising those issues under the Iowa Constitution, the federal Constitution, or both?
It would be both, but predominantly the Iowa Constitution. When this case started, it never occurred to me that the mother would not be afforded a parental preference when the court was determining whether or not to terminate the guardianship proceedings. It never occurred to me because in all of the years that I have been dealing with minor guardianships, the parental preference was always an important factor, and for good reason, given the compelling interest of a parent-child relationship. At the conclusion of
the affidavit, for example, by mom, has it occurred to you ever to include something like, hey, I'm doing this because I'm super young, and when I get my life together, I'd like to have this reevaluated? Is that something that you think would be appropriate for an affidavit?
I think that at the time, of course, I wasn't involved, but the affidavit was presented to the mother. She didn't have it reviewed. The testimony in the record is that she didn't even read it. She signed it under the guise it was temporary, and her belief was that the grandparents needed it to take her daughter on a vacation.
When she signed it, was she how old?
If my memory serves me, she would have been 20, potentially, 20 or 21.
Time?
She did not.
She signed it in 2014, is that correct?
I believe it was 2014 when it was initiated, yes.
The grandparents had already been, the child had already been living with the grandparents for several years, right?
The child has lived with Grandpa and Grandma all her life.
11, right?
But for a majority of that time, the mother was living in the home with them. It was in 13 when the parties separated that she went and lived with just the grandparents.
The child went to live just with the grandparents in 2013. Then in 2018 is the letter where she asks to terminate the guardianship, or asks about terminating the guardianship, right? And reading that letter, it makes it sound like that's the first time she's raised the issue. Is there any evidence in the record she raised the issue before 2018?
There is Evidence in the record that she had consulted with attorneys in 15 and in 17. There is evidence in the record that there were text messages between the father and the grandmother prior to 18. And there is evidence that she was obviously concerned about broaching it directly with the grandparents due to her intimidation and her fear that she would be unable to see her daughter, which was such an important thing for her to be able to do.
Just for purpose of my question, that we're going to apply a best interest of the child standard. The high water mark, I think, of the other side is one of stability. It's been many years that the child has lived in this home. She's now approaching adolescence. The continuity that would be afforded by staying with grandma and grandpa is something of great value. What's your response?
Say that I don't think we can get to the best interest if we don't first consider the parental preference of the mother.
I'm going straight to the best interest.
And interesting enough, but the therapist testified and was questioned about what would have to happen in order for this transition to go smoothly for the child. And in fact, she provided, not really that long of a list of what needed to be done. Continued therapy, continued contact with the guardians, of course, and contact with the school counselor to help with the transition to a new school because that was envisioned. The mother was committed to doing all of those things, and not just by her own testimony. I believe everyone supported the testimony that the mother would certainly support that as part of the transition and knew it had to happen.
I understand those aspects of the record, and I think you've been accurate about it, but if the test is the best interest of the child, on the one hand, you've got the continuity of 11 years. Mom was there for part of it, living in with the grandparents, but you've got the continuity of a very successful arrangement. That strikes me as something in the balance on the best interest, certainly. And what do we have on the other side, and how would the balance come out? Is it conceivable that the logistics could be worked out to execute this change? I don't doubt that is, but if it's the best interest of the child, why would the switch now at 11 years old make sense?
And, I don't think we get to best interest, but if we are at the best interest part of it, then you have to recognize that when the child was 9, so approximately 2 years before this happened, therapeutic intervention was required because she was struggling with her relationship with her parents. She wanted more time with them. She needed more time with them. And that really is why therapy was initiated. I double-checked the record. Therapy was initiated because she was wanting more time with her parents, which goes directly to the issue of why the parent-child relationship is so critical.
Parent-child relationship. As I read the record here, mother was almost never denied time with the child. I think her testimony was it was a couple of times a year when the child had some activity that was already planned. Other than that, anytime she wanted visitation, she had visitation. Is that right?
It must have been more than that if the child was concerned about having more time and not liking that there wasn't a consistent schedule. So it seemed that the schedule was in fact open.
Your client's testimony that it was a couple of times a year?
Well, yeah, I think it was a few times a year where she was denied time with the child. But the fact of the matter is she wasn't getting as much time as she wanted because there's other factors. The father had to have time, the child had activities, so she wasn't getting as much time as she wanted, and I believe that's part of the record as well. It's not just about the denial by the guardians of time with the child, but it wasn't enough time, and it clearly wasn't enough time for the child, or she wouldn't have had these issues that required therapy.
Give the child's father's parental preference that the guardianship continue?
So the father, of course, didn't want the guardianship to terminate, and he thought it should remain intact. I think there are all sorts of things I could say about that. I don't think that he was in a position to fight with his parents about this. They obviously were on the same page in reference to that. The mother and the father had had conversations over the years about terminating it, and the mother wanted him to be on board with her because she knew fighting his parents was going to be difficult in and of itself, thinking him being on her side would help alleviate that. So his parental preference of keeping the guardianship in place, I certainly think it could be considered, but if you have a safe and stable parent who is not unfit and we don't give her a preference, then her rights have not been protected when we deal with a guardianship.
Cases indicate that a parent can waive the parental preference by taking an extended absence from parenting. What evidence in the record would indicate here that the mother exercised some sort of parental responsibilities during the course of the guardianship?
And I think the regular visitation, the regular phone contact, the support that she provided in buying clothes and shoes, I think, and I wanted to check this, so
Direct financial support to the guardians?
testimony was that she was never asked. Had she been asked, she certainly would have done that, and the father had never done that either. One of the things that struck me was the guardians didn't notify the parents of everything that was occurring. And I think, the grandparents testified that, well, we did it first, but then they didn't show up, and so we just stopped doing it. So it was somewhat of a frustration in the mother's testimony that she didn't know about these things. If she knew about them, she would have participated. And in fact, when she was asked,
The passage of time in and of itself could be sufficient to eliminate the parental preference.
I think there are circumstances that certainly the passage of time would allow for that. I don't think this is the case. I don't think you could ever put a set number on it, and I don't think that in and of itself would ever be enough if you didn't look at all of the other factors, including the relationship and the contact and the various parts of what it was that was happening for her to have the relationship that she continued to have with the child. And again, back to the child was struggling with this. So it doesn't matter how much time passes. If the child is struggling, I think we have to address that issue.
The therapist's solution, though, was for more regular visitation and not for a termination of the guardianship. So you're kind of, you're selective in what you're asking us to adopt of the view of the therapist, right?
And as the district court found, is that recommendation by the therapist had been made over a year ago, and yet there had been no set schedule devised by the guardians. Nothing had been done to follow up with that. The reality.
Comment in his report, I can't remember for sure, that when he talked about a visitation schedule, her face lit up or something like that, that the girl wants a set schedule. I believe it was in his report.
Well, I do vaguely remember that was something that was discussed, but it was, in fact, told to the guardians by the therapist when she initiated the counseling for having contact with her parents. And
Mutual responsibility. It's responsibility of the guardians and also of mom to work toward a regular schedule, right?
guardians are in control of the schedule and never do anything to put forth a set schedule. What would the mother be able to do about that? She wouldn't be able to do anything.
Appeals opinion, when it was discussing the word harmful in 232D 503, I think it concluded general anxiety is sufficient to establish harmful effects to the child. How would you define harmful, and should we look to other provisions of 232 that might indicate harmful requires something more severe than anxiety?
It would be my position that harmful would require more than that, especially on this record when the therapist has given us the tools to show that the transition can happen and that it doesn't have to be harmful for the child if therapy continues and the guardians continue to be part of the child's life. So I think the problem, and again, I don't think you have to get to the determination of harmful if you determine that the parental preference exists and that SW was not an unfit parent, because at that point in time, the child gets returned to her.
Even if we assume there was a parental preference, that could be overcome by a showing of harm to the child. So don't we necessarily have to define what is harm within the meaning of the statute?
Do not find that SW is an unfit parent, you never get to that balancing test to determine if there is harm, because that is the problem, and that's why it's not narrowly tailored enough, because we don't have to let the courts decide what is in the best interest if we have a fit and able parent. And the district court certainly found that she was, and the Court of Appeals did not find that she was unfit in any way.
Who has the burden of proof here, and by what showing? Preponderance or clear and convincing?
The district court used preponderance of the evidence, I think more in line with what the case history has been in these types of cases. Clear and convincing evidence is necessary. I think the burden is on the guardians that the guardianship continue like it has been. And my time is up. Thank you.
Ericka Petersen with Legal Aid.
Good morning. May it please the court. Counsel. I'm Ericka Petersen of Iowa Legal Aid on behalf of Amicus Curiae, BMR. Shortly after the birth of her child, BMR's partner was suddenly and unexpectedly deported and later murdered. With the traumatic loss of her partner, her child's father, and the person she relied on for childcare so that she could work to support her child, she looked for family for help as she prepared to take on her role as a newly single mother. A family member took the child while she did that, and when she sought to get her baby back, she was instead served with guardianship papers. Unfortunately, BMR's story is not unique. In its 44-year history, Iowa Legal Aid has helped hundreds of parents reunite with their children when a guardianship was either misused or no longer needed. Because the language of the minor guardianship statute has been changed, the grandparents in this case urge, and the Court of Appeals appears to have applied, a mere balancing test between a natural parent and anyone else. That should send chills down the spine of anyone who has ever known the parent-child relationship. And it is for this reason that the U.S. Supreme Court and the Iowa Supreme Court have protected the child-parent relationship for over 100 years. The right to parent one's own child is a fundamental liberty interest. That interest can only be infringed upon when it narrowly serves a compelling state interest. The analysis for guardianship must always begin with the threshold finding of unfitness.
It strikes me there's sort of two separate issues. Nobody is talking about terminating the mother's parental rights. Normally, when we are talking about a constitutional claim or a constitutional right, we're talking about protecting the parental rights. I mean, it seems to me that where the mother would end up if under the Court of Appeals decision is not in that situation. She obviously is always going to be this child's mother, but more like a divorced parent who doesn't have physical custody of the child, who has to exercise regular visitation. Isn't that a different constitutional issue than the termination of parental rights issue?
The first point is we actually found these fundamental rights when we were considering grandparent visitation, and that was deemed too big of an intervention into the natural parent's right. So it seems to me that an intervention where we take away the child from the natural parent, that is more of an intervention than just grandparent visitation. But more than that, while I know termination is a very specific legal term, in many ways it is effectively. She has no route out, and the only thing she's ever done is sign a paper at 20 or 21. And this was prior to the new statute. The new statute provides a little more protection and what we'd like to see before a person signs away their rights, right? She just signed an affidavit at 20, low education, not likely knowing or understanding legal rights.
Point, I'm going to be raising that issue with the Grandparents' Council. But still, nonetheless, it's not that the only thing she did was sign away the piece of paper. If she had signed that piece of paper and then a year later came back, wouldn't you agree that would be a different case than here, where she signs the paper and then for 4 years does not raise any issue, and at this point now, when we're in court, the child's 11 years old and has been raised by the grandparents her entire life. Isn't that something that should be taken into account?
Into account. And I might have a different perspective if, as a legal aid attorney and speaking with many of my fellow legal aid attorneys, we hadn't seen this 100 times. The power dynamics, once a guardianship is entered, are very complex. You also have the family dynamics. We've seen from our line of grandparent cases that the family, or anyone who has children and grandparents, that those dynamics can be very complicated very quickly. It's easy for a grandparent or someone else taking on the parent role to think, I do a better job. And then they bond with that child and they don't want to lead in that relationship. And so, the association, the Iowa Guardianship and Conservatorship Association, they talk about this lesser level of unfitness than a DHS China. And in some cases, a guardianship is a really important tool to help protect children. But in some cases, it's a huge intervention into a parent-child relationship with far, far fewer protections and far less, and often very difficult to navigate out. And we've seen that many, many times.
But that's okay, because I'm going to ask you a question, and so you get a free pass here. Justice Mansfield brought up an issue about, well, isn't this just like, can't she just get visitation and things like that? I'm comparing this to a bio mom and dad, whether they've been married or not. Help me get through this. Chapter 598 gives them all kinds of protection to get visitation, to be involved in educational decisions, to be involved in medical decisions. What this mom has is far less than that, correct?
She is far less.
Said that effectively her rights kind of have been terminated. What does she have as a biological mom, other than the biology? What right does she have under this guardianship?
The Court of Appeals decision stands, none.
Thank you. Mr. Baltimore, on behalf of the Iowa Guardianship and Conservatorship Association.
Thank you, Your Honor. May it please the court and counsel, my name is Chip Baltimore. I'm here on behalf of the Iowa Guardianship and Conservatorship Association, and our interest in this particular matter is in trying to advocate for a proper interpretation of Iowa Code Chapter 232D. We believe that the Court of Appeals analysis was incomplete, and we believe it was incomplete because it ignored one simple reality, that upon withdrawal of parental consent, the voluntary guardianship, once it was deemed to be or desired to be continued, was converted into an involuntary guardianship. And when you convert that into an involuntary guardianship, that raises the constitutional concerns and constitutional matters.
It was a voluntary guardianship. It was voluntary. She signed it. He signed it. And then it was revoked. How can you all of a sudden make it be a different category just by a title?
Because the entire basis for the initial guardianship was the consent. And when that consent was withdrawn, then the basis for that goes away. And in our opinion, voluntary guardianships do not bring into play the constitutional rights of the parent, because they are foregoing those at that point in time when they sign that consent.
And you believe that they said, even though it's not in writing, that they gave up their fundamental rights?
At least in part, yes, they did. So in our opinion, once this becomes an involuntary guardianship, that is an infringement upon the parent-child relationship that brings into play the substantive and procedural due process concerns under Article 1 of the Iowa Constitution.
Do you believe the repealing of a statute can take away a fundamental right if there is a fundamental right?
Constitutionally, no.
So then your position has to be that there's no constitutional right. Is that because previous to that statute, our common law already recognized parental rights as a fundamental right, correct? So we really didn't need the statute, I guess.
The statute, the prior parental preference in the prior code before the 2019 reforms, I think it was just a statutory codification of at least the legislature's attempt to codify what had already been in common law.
What impact does removing that clause then mean?
It puts us back into the situation where you do have the underlying constitutional rights of the parent-child relationship, but I think we have to look at what the legislature replaced it with. And in our opinion, the proper analysis has to look at all of the provisions of Chapter 232D as a whole, not just under 503 sub 2, but when it becomes an involuntary guardianship, in our opinion, you have to go back and take a look at the provisions of 232D.204, which are the bases for establishing an involuntary guardianship. Now, we think that that's important because we believe that subsection 204 is the legislature's determination of some minimal level of parental unfitness that warrants an intrusion, a compelling state interest, and the narrowly tailored means by which those parental rights can be infringed upon. So I think that when we look at the chapter in its entirety, you have to look at what it was replaced with, and it was replaced with this structure under the new 232D in its entirety.
I mean, persuade me otherwise. How can a guardianship result in a parent having less rights to challenge than they would against the other biological parent?
In terms of this situation, when you've got somebody stepping into the shoes of the parent that is not the parent, that guardian then becomes, in essence, the de facto parent.
About those 598 things, you know, there's lots of things a parent, they don't have, there's difference. There's a huge difference. And so help me understand that. Is that really the intention, do you think, of the statute, to give a parent who wants to challenge a guardianship a harder road to bear than if they were challenging another bio parent?
I don't believe that that's the case. I think that the statutory scheme under Chapter 232D, particularly when it comes to the involuntary guardianships, is very narrowly tailored to a very limited set of circumstances to meet that compelling governmental interest that is necessary to satisfy the substantive due process requirements of Article 1. And again, if you look at 204, those are very narrow circumstances that an involuntary guardianship is allowed. And so while the infringement may be somewhat more than under 598, that's what the legislature is determined to make them very, very narrow.
I know the light is red, but you have to switch to involuntary to make your argument work. And I'm having a really hard time when a case is filed under one section, facts change, and now you're going to say that it automatically was as if it was filed under a different section. We can't do that. For example, if somebody wants to terminate someone's parental rights and they're alleging abandonment, and then all of a sudden they have a better reason on the day of trial, and all of a sudden they change ships and say, never mind, let's pretend like it was or if it was consent. We can use that as an example. Say it was consent to begin with, and then consent was withdrawn on a TPR, and all of a sudden they allege something else for the first time. How can you just make it by words? I don't understand. It doesn't say that in the statute.
I think that the difference is that the voluntary guardianship is established, and when it is established, it does not bring into play the constitutional concerns. But when the parent withdraws that consent, it's de facto involuntary, and that does raise the constitutional concerns that we believe are in play under the other section of subsection 204.
constitutional concern, you are saying that we don't have to look at parental preference anymore because they repealed that?
I believe that the parental preference is established under Article 1, under the substantive due process rights of the parent-child relationship. That's the remaining parental preference to the extent that, that there is one that remains.
Anybody else? I took some time there. Thank you.
Thank you.
Mr. Howie.
Good morning, Your Honor, Counsel. I represent the paternal grandparents in this case who are the guardianships of the minor child at issue in this case. Let's bring us back to the facts of this particular case. And what has already been pointed out, what is undisputed, is that my clients have been effectively the only consistent parental influence in this child's life for her entire life. Now, with the guardianship as to what we're doing here is we have a mom who, after years, knowingly, willfully consented to the guardianship that was entered. This is a voluntary guardianship in case we ran afoul based upon what other people have said. My clients have done everything right. The child has thrived under my client's care. She is healthy, she is wise, she is well established in her church, her friends, her family, and
disputes that. Can you get to the meat of the matter, parental preference? I mean, we could take a bus and go down to a big urban area and pick up a whole bunch of kids and we could find a better home for them. We could always do that. So we're not, I think this whole system, if anything, is acknowledging that they did a fantastic job. Help me understand how they get to be above a parental preference on a constitutional level.
Well, Chief Justice, let me just explain this in terms of, yes, the legislature repealed the statutory preference that used to be under the guardianship code. So that's there. Now, does that repeal a fundamental liberty interest? Absolutely, it does not. In other words, mom still has her fundamental liberty interest to exercise that in the guardianship proceeding. Now, what we have is we've got a new regime. We've got a new statute where mom, for the first time under the old code, mom couldn't petition to terminate the guardianship. So that, in a way, in and of itself, is recognizing the fundamental liberty interest. Second, mom can bring that petition to terminate, and then she has, under 203 and then under 503(2), there are specific rights and responsibilities that all the parties and the court must consider as to whether or not the termination is there. And I think what the Court of Appeals put out in its four questions it asks was a strong balancing test. And so I respectfully disagree with the Conservatorship Association. I respectfully disagree with the Iowa Legal Aid. This is not some major influx of destroying parental-child relationship. That is not this way at all. What the new statute does is it recognizes the fundamental liberty interest that this court has recognized for decades.
Test, don't we have to find harmfulness first? Doesn't the statute require harmfulness before you get to the balancing test?
Exactly what SPG standard came down with the Court of Appeals and how the Court of Appeals analysis.
McDonald's question earlier, what does harmful mean in this context? Is it the short-term harm that's probably going to always arise when you're adjusting a child, especially if they've been living with someone for a while? Or is it the type, how do we define harmful?
Harmful, I think, is exactly what the district court implied and what the Court of Appeals found is both short-term and long-term. And so therefore the court should consider the harmfulness as to what is there. And let's apply that particular standard to the facts of this case. In this case, the Court of Appeals correctly found it would be harmful because mom had been in absence from a child's life. Now, wait a minute. Now, it's not like she was completely absent. And I'm not implying that at all. But at most, she was a parent of convenience. She would only see the child when it was convenient to her, approximately every other weekend. Sometimes it was in the record she would go 4 to 6 weeks. Also, there was evidence in the record.
To the association's point of looking at the involuntary and that being some kind of a minimal unfitness, is harmful in any way related to unfit? Do we look at the China standard for what is it that harmful just seems like a very amorphous concept, and it would be very easy to say harmful anytime you're rearranging what a child's situation is.
I think I'm starting to get Your Honor's point. In terms of harmful, then we get into the best interest analysis. Is certainly.
Is that right? Yes. Okay.
Just make sure I understand. Let me restart again in terms of the harmfulness and best interests. Is that, yes, I think it's within the court's purview to determine whether or not terminating the guardianship is harmful considering the best interests of the child. Now,
Question for me is define harm. And are you saying that generalized anxiety is sufficient harm? And if so, how is that consistent with the constitutional right that requires a showing of parental unfitness or unsuitability?
Your Honor, I don't believe general anxiety is enough. I think when you look at the case from all different aspects of it, dare I say the totality of circumstances, certainly the anxiety the child would suffer is one part. But we didn't just have a general anxiety like we have in most dissolution cases where mom gets it or dad gets the child. What we have here is we had a therapist. We had expert testimony where the therapist had an established relationship with this child for 2 years, saying the recommendation was to stay because the child was much more comforted, that there would be significant psychological anxiety. We have those facts. We didn't have to speculate about that in this record like a court may have to do in another one. And yes, Your Honor, you do need more than just general anxiety. Absolutely.
The code defines mental injury to a child under 232 as something that requires a diagnosable condition that would cause long-term injury, basically failure to thrive from a mental aspect. Do we have that in this case?
Yes. We do. It's the potential. It's the future. What is the issue facing the district court? Is that we have a child who is thriving in guardian's care. We have a child who has exhibited symptoms and has a potential diagnosable situation that if we remove her from guardian's care, there is going to be a psychological diagnosable effect. Those are the facts we have in this particular case. I'm sorry, I can't remember the exact diagnosis, but I know that Dr. Rudman certainly testified and she was cross-examined as to why it was her recommendation that the guardianship remain, and it was because, I think it was, the Court of Appeals hit on it. It was perfectionist tendencies was one area on it.
Them though, was it, the diagnosis?
Your Honor, I apologize.
Just also say I've never met with the mom, and also that transitions, and we all know transitions. Transitions are tough even between a loving mom and a father who are separated. Transitions are tough. And let's talk a little bit about the facts that we don't have. This is an unusual case. No drugs, no alcohol, no sex abuse, no physical abuse, no domestic abuse. We have a young girl, 16, who signed this, right? So when you're talking about harm, no, but when she was 16, she had the baby. When you talk about harm, I don't think anybody's alleging there's harm in the grandparents' home. And I haven't heard an iota of harm with mom. Where's the harm? You would go with mom. If you have to assume that any transition would be difficult, because I think from the record it would also be difficult for her to not have regular visits with her mom. So assume that you can't use that as the harm. What harm is there on mom's side?
On mom's side was the inconsistency was there, and that I think is what has been misconstrued. I think the district court got it wrong, and that's where the Court of Appeals got it right, is in fact the harm that was exhibited by the child in this particular circumstance, if she went with mom, was then the lack of regular contact with the grandparents, the guardians, because now mom would have complete control and she could cut them off. She testified she wouldn't, but that is something to consider. Another thing is that she would have to completely remove homes, churches, friends, extracurricular activities. Those certainly should be considered by the court, and the Court of Appeals properly did.
Maybe account for why she wasn't able to do all of those things, that 40 miles one way, back and forth. You want to use those arguments as a reason not to do it, but isn't that also an explanation to help understand why mom, who works full-time, might not have been able to do that?
Basis, Your Honor, but then we look at the situation as to what has happened. We had mom who was only visiting her child when it was convenient for her. There was testimony in the record that the child was anxious and very upset when there was a planned phone call and mom didn't call. And there were also times where periods of weeks where mom would simply disappear and not be there. And that is something that the court should consider. The district court didn't. The Court of Appeals did. And that is why I think a fundamental basis as to why the Court of Appeals got it right. Oh, sure.
The code does identify harm or define harmful effects as including mental injury, but it says it has to be a non-organic injury to an intellectual or psychological capacity as evidenced by an observable and substantial impairment in the child's ability to function within the normal range of functioning. Is there evidence in this record that she would suffer an injury that would cause her to function outside the normal range?
That effect because it never got that bad. What was commendable about the guardians in this particular case was as soon as she started exhibiting, I think it was fits of crying and very upset when mom didn't call. And so therefore, my clients, the guardians, got her the therapy that was there. And so therefore, she headed it off at the pass, which was positive and commendable of the guardianships. So no, we don't have that dire situation because my clients, again, did everything right.
And when they were asked in writing for more visitation, did they ever give her a written response or any kind of a visitation schedule?
The record, Your Honor, is the only evidence of any written request to terminate the partnership was the guardianship was an undated, unsigned letter that was put in by the mother in this particular case. And so therefore, there really was no communication.
Was it?
Was, Your Honor, and with all due respect, I think my clients, that if they did, what also is undisputed is when she filed the petition to terminate, that was the first formal action she'd ever taken. My clients disputed that she never got a letter from a lawyer, never got any type of contact. And so therefore,
If she hadn't done the consent, doesn't the consent seem to be one of the most beautiful gifts a parent could give is an acknowledgement, I need help. I need help. And they were there.
absolutely.
And so help me understand, what message does that send? I don't know what mom has done worse than signing a consent.
And that's not the guardianship's point. The guardianship's point is that the guardianship should remain intact because, one, the whole case began as a consent. And during those many years, 8, 9 years, where my clients were the sole parental role makers in this young child's life, mom only visited or called when it was convenient for her. She did not contribute financially to the guardians. She didn't show up at I think, 1 doctor's appointment, 0 dentist's appointment. And so therefore, it was wrong for mom to then somehow put the blame on the guardians. No, this was mom's fault.
Court heard all this through live testimony and terminated the guardianship. Shouldn't we give some deference to its findings?
This is de novo review, and absolutely this court should give credibility determinations.
A order. Did the child remain with the guardians? What
was entered?
By agreement of the parties, the child remained with the guardians? Okay.
Stay.
The standard that the burden should be on the guardians to prove by clear and convincing evidence that the guardianship should continue.
Interesting point based upon the new statute. The new statute is silent on that particular fact, and what the district court did is, I think, correct in terms of put the burden on the mom trying to terminate. The moving party should have to have the burden to prove it, and it should be by a preponderance of the evidence. Now, why is that? Look at the 4 factors that the Court of Appeals did in SPG. The 4 factors are very important. They consider the fundamental constitutional interest. They weigh it between the child's interests, the parent's interests, the harm, and then how that overall weight should be considered by the district court.
And that legal aid raised that I think is a valid one. Isn't there kind of a little bit of a bait and switch in that the mom signs a consent under an old legal regime, and it's a consent that doesn't have all the bells and whistles that the current consent would have, and yet now we're applying the new legal regime to the termination. Isn't that problematic?
Whether it's problematic, that's what the legislature did. And so I think the ultimate problematic for this court,
right,
of where we are now and what this court should do is, was there a constitutional flaw to the new 232D, specifically 203, 204, and 5032? And my response to that is no, there is not. Because what the legislature is doing in terms of the harmful balancing test that is there is they're looking at it from a bird's eye view, looking at everybody. And what's interesting is yesterday in preparing for this, I found a case that I didn't cite before, but this court handed down in 1925 that said that a guardianship proceeding is non-adversarial. It's non-adversarial because the court is supposed to look at it from all sides and consider what is best for the protected minor. And so applying that 1925 case to today, we don't have to reinvent the law or redo anything. I think what it is there is not a bait and switch, is 503(2), and the way SPG, that ruling by the Court of Appeals does, adequately protects everybody involved.
For your 1925 case?
I will look it up, and I will file it after today's oral argument. I just don't have the citation memorized.
I'm going to get back to that 598 thing. Under 598, two bio parents can duke it out in court. And whoever is the one that may, if it's not a shared care arrangement, one of them is going to have primary care and the other one's going to have visitation. They're still legal parents. They still are allowed to do certain things. Right now, doesn't it seem like the new statute is even better in this situation? I'm not going to say grandparents because it's guardians, but it happens to be grandparents. Even better than the old school grandparent visitation statute we used to have that was overruled by Troxel and Santee. They get custody now. That was just about visitation. This is custody. Help me understand how this doesn't even tighten the screws tighter.
In my opinion, it doesn't, Your Honor. First off, the grandparent visitation statutes, I think, are completely inapplicable. What they did is they took the fundamental liberty interest and they applied it to an incredibly broad visitation statute between two fit parents. Okay? This is a guardianship setting. This is not a China setting. This is not a termination of parental rights setting. This is not an involuntary guardianship setting. That's why the compelling state interest in that this statute is narrowly tailored is it only applies to the voluntary guardianship is here. And so therefore, Your Honor, I don't think it's an appropriate analogy, and I have to respectfully disagree that just because the guardians happen to be grandparents, no, they don't. It's still a guardianship statute factored under the guardianship regime under the very narrow aspects of 503(2) in terms of terminating.
Thank you.
Thank you, Your Honors.
Ms. Eisentrager, not sure if I said it right.
Just for point of clarification, there was in fact no stay issued in this case, and I think that it was unclear in what happened there, but the guardians do not have L.Y. in their care. I do want to go back to the passage of time and the concern by the court in the passage of time. So for 4 years, we have the mother parenting her child on a day-to-day basis while living in the guardian's home. She is at every appointment of the child. She is doing everything that needs to be done to care for her child. That happens until the parties' relationship breaks down and she moves. She moves and needs time to get settled. She consents, and now she's stuck. She can't get out of this no matter what she does, and she feels like she can't do what she needs to do to get out of it because she's intimidated by the guardians. They're not helpful in that regard, and she feels inferior to them. If you look at matter of guardianship SKM, that was a significant passage of time, and yet the parental preference was given to the father because he had not waived that preference by not being an active parent involved with his child, and the relationship was very bonded, very similar in this case. And so I think that one goes to that passage of time, that there can be a significant passage of time and it's still okay. We still have to recognize the parental preference. So back to the issue of harm, I don't think you get to any balancing test if you don't first find harm. And there is no harm here. The mother has been actively involved. The child knows, loves her, wants to be with her. And so without harm, I think that you can pass the constitutional muster because you never get to the balancing test, which allows the court to balance between the guardians and the mother, which then leads to the infringement of her rights.
I'm in the SKM case.
SKM, the child was born in 2007, and it was a 2017 case. I think 2013 might have been the time frame when it was initiated, and so it wasn't,
Guardianship, roughly.
I think, yes.
To look at this as an involuntary? Why not?
To that, this was absolutely a voluntary guardianship done by consent. I don't know how you just magically get to the involuntary part of it. If, again, the district court found that there was nothing wrong with the mother. So I'm not sure how we could ever get to the involuntary part of it when none of those things are there to even consider.
In their briefs, talk a lot about things mom did not do. I wanted to understand a little bit more. For example, medical appointments. Was mom consulted before appointments were made? No. Were those kinds of appointments made in the geographic vicinity of the grandparents?
So Grandma worked for a pediatrician. Grandma simply scheduled the appointments and took the child. She may or may not have told mom and dad about them after the fact. I believe her testimony was she claims she told them and then they didn't come, so she just stopped telling them. But what's interesting about that is if mother had attended every single appointment while living in their home and caring for the child, and now suddenly she doesn't go to appointments, but yet the record shows any appointment she was asked to attend or take the child to, she did. I think the one instance was the child had a therapy appointment while in mom's care for the week during a summer week, and the mother took her.
By the appointments, I mean, you don't need multiple parents a lot of times at a doctor's appointment, or multiple guardians or multiple whatever. But what does trouble me is the therapist, Dr. Rudman, who doesn't see, the psychologist who doesn't seem to have an axe to grind at all, says, well, according to the child, she was unsure why her mom was asking for sole custody when they didn't really have a consistent visitation in her eyes. And it's that lack of a consistent effort to see the daughter that I think it was identified as by the therapist. And is the therapist just wrong about that?
What kind of was fleshed out in the testimony was that the child here wouldn't know when mom was requesting or what mom might have been being told about why visits could or couldn't happen. So there would be periods of time where there might be, 3-4 weeks that she didn't have visits with her mom, but she wouldn't have known why that would have been if the mother had called the guardians and asked for a visit but wasn't allowed because of some other conflict in the schedule. So the child wouldn't have known that. So she just would have known, I haven't seen mom in 4 weeks. But she wouldn't have known why. So that was part of the testimony. I'm sorry?
You may wrap up.
So I think the court here has to affirm the district court findings. They were thoughtful, they were thorough, there was no harm here. SW is not an unfit parent. There is nothing unfit about her at all. She is entitled to a parental preference. She is entitled to custody of her daughter. Thank you.
In Guardianship of L.Y. is hereby submitted. The next case is Klein versus Iowa Public Information Board and Burlington Police Department et al.